Imagine walking into your local sheriff's office to get a concealed carry permit, and they tell you, sorry, self-defense isn't a good enough reason. Sounds insane, right? Well, that was the law in New York and California, and half a dozen other states that treated the Second Amendment like a suggestion, not a right. Until now. In a jaw-dropping 6-3 ruling, the Supreme Court just obliterated a century of anti-gun laws in one clean shot. The case? New York State Rifle and Pistol Association versus Bruen. The result? A total rewrite of how gun rights are protected and how states are no longer allowed to block your carry rights with bogus excuses. And here's the twist that should make every gun owner furious. While gun owners across the country are celebrating a historic win, blue states are already plotting workarounds. Bans disguised as sensitive places, sky-high fees, endless paperwork. They're not giving up, and neither should we. This decision was the spark. But what comes next could either secure your rights for a generation or bury them under a mountain of new legal traps. Stay sharp. Stay tuned. This is not just a court case. This is a war for the Second Amendment. So how did one Supreme Court case blow the doors off a century of gun control? Let's break it down. This case that shattered the old system was New York State Rifle and Pistol Association versus Bruen. And if you've ever been told your right to carry depends on good enough reason, this is the case that changed everything. For over 100 years, New York operated under a rule called proper cause. Translation: you had to beg the state for permission to carry, and just wanting to protect yourself didn't cut it. You needed a documented threat, a stalker, a restraining order. If you were a law-abiding citizen without drama in your life, too bad. No threat, no permit. That wasn't just unfair, it was unconstitutional. And in June 2022, the Supreme Court finally said it out loud. Justice Clarence Thomas delivered the knockout punch. In the 6-3 majority opinion, he wrote that the Second Amendment doesn't need modern approval to exist. It's rooted in America's foundation. From now on, any gun control law has to pass a new test: text, history, and tradition. What does that mean? It means no more hypothetical public safety arguments from politicians, no more emotional appeals about what might happen. If the restriction didn't exist in 1791, it has no place now. As Thomas put it, the Second Amendment is not a second-class right, subject to an entirely different body of rules. This wasn't just a technical legal tweak, it was a tectonic shift. For the first time, courts are being forced to look backward, into the founding era, to justify modern gun laws. And most of them? They don't hold up. That's why anti-gun lawmakers are panicking, because they know this wasn't a narrow decision. It was a wrecking ball to their entire playbook, and it's only just getting started. So ever wonder how courts used to get away with stripping your gun rights while claiming they were protecting the public? Simple. They didn't care if a law stomped on the Second Amendment. So long as the government said it was for safety, they called it good. But that game is over. The Supreme Court ripped that system out by the roots. No more interesting balancing. No more hand-waving about crime stats or policy goals. From now on, if a law limits your right to keep and bear arms, it has to pass one brutal test. Does it line up with the text of the Constitution, the history of gun laws, and the tradition of how firearms were regulated when this country was born? That's the new standard, and it's cutting through anti-gun laws like a buzzsaw. Judges now have to ask, was there a similar restriction in 1791? Can the government point to a historical twin from the founding era? If not, that law is unconstitutional, period. And yes, we've already seen it in action. California's 10-round mag cap struck down. Restrictions on public carry zones, falling one by one. Transportation bans, modern licensing obstacles, gone, or getting shredded in court. This text, history, and tradition standard isn't just legal jargon. It's the wrecking ball the Second Amendment desperately needed. And the truth is, most of these modern laws were never built to survive scrutiny. They were designed to control, delay, and deny. Now, they're collapsing under their own weight. And for gun owners across America, that means one thing. The courts are finally on notice. No more loopholes, no more excuses. The Constitution is back in the driver's seat. So what does all this courtroom drama actually mean for you? If you live in a pro-gun state like Texas or Tennessee, your world didn't change much. You probably already have shall issue carry or even constitutional carry. But for folks trapped behind enemy lines, California, New York, Maryland, this ruling was like a door finally slamming open. No more begging, no more groveling to prove you're special enough to defend yourself. The state can't demand you show some stalkers threatening text messages just to get permission to carry. Meeting the legal requirements, age, background check, training, that's now enough. Period. But don't start celebrating just yet, because anti-gun states aren't backing down. They're just shifting tactics. They're adding character references to your permit process, doubling or tripling the fees, dragging out wait times, requiring you to complete expensive, multi-day training that's only available at 3 locations statewide. All of it designed to make you give up before you even get started. It's a war of attrition now. They can't block the front door, so they're clogging the hallway. That's why it's critical to know your state, know the games they're playing, and most of all, know your rights. Because the law is on your side, and these bureaucratic tricks can't stand forever. If you've been denied before, apply again. If your state is inventing new loopholes, challenge them. The Bruen decision wasn't a gift, it was a weapon, but it only works if we use it. So use it. Challenge every delay, expose every workaround, and remind them our rights don't end at state lines. And the moment that message hit the courts, everything started to shift. Because once Bruen dropped, the lawsuits started flying coast to coast. From Illinois to Oregon, gun owners, advocacy groups, and constitutional lawyers saw one thing clear as day. This wasn't just a ruling, it was a loaded precedent. Suddenly, every single gun control law that relied on vague public safety claims was now on the chopping block. 10-round mag limits, challenged. Waiting periods for background check buyers, challenged. Assault weapon bans based on scary cosmetic features, challenged. Restrictions on transporting firearms in your own car, challenged. And here's the part that'll make your blood boil. In California, a federal judge struck down the state's magazine ban, calling it unconstitutional under Bruen's historical standard. Why? Because there's zero historical precedent in 1791 or even in 1868 for telling people how many rounds they were allowed to carry to defend their life. Other cases are bubbling up fast. Maryland's rifle bans, New Jersey's carry restrictions, Massachusetts' home storage laws, all getting picked apart in courtrooms that now have their marching orders. No more interest balancing. If it doesn't align with the founding era, it doesn't fly. And you better believe this legal earthquake is just beginning. Appeals are pending. Judges are writing decisions with Bruen in the margins. And eventually, the Supreme Court will be forced to weigh in again to clarify, to reinforce, or to strike down more anti-gun laws. Think of it like this. Bruen knocked over the first domino, and now, one by one, every piece of legislation that treated the Second Amendment like a second-class right is tipping over. So stay tuned, because the legal landscape is shifting fast, and the road ahead is paved with opportunity and resistance. But let's not pretend this is a clean sweep, because the resistance is alive, loud, and fully armed with bureaucracy. Blue states didn't take the Bruen loss lying down. They pivoted, fast, If they couldn't stop you from getting a permit by denying proper cause, they'd make the process unbearable instead. Sound familiar? Now we're seeing outrageous training requirements, sky-high permit fees, weeks-long delays, and character evaluations that feel more like job interviews than civil rights. Some states are even demanding references, as if you need a friend's permission to exercise a constitutional right. And just like that, the new strategy is clear: stall, confuse, and frustrate law-abiding citizens into giving up. Death by paperwork. Take New York's response. After Bruen, they rewrote their law with a laundry list of sensitive places where carry is banned: Times Square, public transit, parks, churches, even libraries. The goal? Make carrying legally so difficult that most people just stop trying. And here's the kicker: some lower courts are letting it slide, at least for now. Which means one thing: we're not done. The anti-gun machine is regrouping. The headlines will spin, the politicians will posture, and the court battles will keep stacking up. If you're a carrier, a gun owner, or just someone who believes rights shouldn't be subject to permission slips, you need to stay alert, because winning a Supreme Court case was just the opening move. Now, the real fight begins. So here's where we stand. The Supreme Court fired the first shot with Bruen, and the shockwaves haven't stopped. Across the country, old laws are falling, new laws are rising, and the battle lines are being redrawn in real time. But don't get comfortable, because while the Constitution is finally getting the respect it deserves, the opposition is adapting. They're rewriting laws, shifting strategies, and counting on confusion to keep gun owners silent. That's why knowledge is your most powerful weapon right now. Know your state, know your rights, and know the game being played behind the headlines. Support the fighters in the legal trenches. Groups like GOA, FPC, and SAF, who are turning courtroom wins into real-world change. Stay loud, stay informed, and help others see through the fog. Because if we let the other side rewrite the rules, they'll rewrite the right itself. This isn't just about permits, it's about power. And the only way to protect your Second Amendment freedom is to understand exactly how they're trying to take it away. Thanks for watching. Stay sharp, stay free, and we'll see you on the front lines right here.